Working in behavioral health or managing an organization in the industry can be challenging. Regulations are constantly changing, and staying compliant is harder than ever. That's where the Behavioral Health Association of Providers can help. BHAP is a national association for those who work in behavioral health or addiction treatment. One of the ways we serve the community is by offering educational opportunities such as CE-based webinars and our certificate in addiction treatment marketing. BHAP also provides advocacy information so you can stay on top of new laws and regulations that will affect how you do business. Our members benefit from simple, effective, and relevant resources that keep you focused on what matters most, the health and well-being of your clients. Helping small and mid-market behavioral health providers access compliance resources and legal education, BHAP is the leading and unifying voice of treatment programs. You can find out more information, as well as sign up for our various newsletters, on our website, www.bhap.us. Hello, I'm glad you could join us today. Welcome to the webinar, Recent Development in the Mental Health Parity Laws, What You Need to Know for Improving Reimbursement. My name is Angie Fiedler-Sutton, and I'm with the Behavioral Health Association Providers. And now, it's my pleasure to introduce our presenters today. John A. Mills is a partner at the healthcare law firm Nelson Hardeman, LLC. John's regulatory compliance work focuses on key issues facing providers that could potentially impede their business operations. He advises clients on managed care and ERISA compliance, voluntary disclosures of possible Medicare overpayments, medical staff and peer review, analysis of business arrangements to ensure compliance with the anti-kickback and Stark laws, and provides regulatory guidance to cover entities and contract pharmacies in connection with the federal 340B program. Zach Rothenberg is also a partner at Nelson Hardeman, LLC. Zach has a breadth of knowledge in the behavioral health space. He advises drug rehabilitation facilities on land use, advocating for clients where administrative actions challenge zoning laws, attempting to prevent facilities from operating in their existing location. He litigates out-of-network and in-network reimbursement cases on behalf of addiction treatment facilities and responds to special investigation audits. He is also advised on labor and employment defense matters, including those related to racial discrimination, wrongful termination, wage and hour disputes, and retaliation. Clients have come to rely on his insight regarding employee handbooks and labor code issues. John and Zach, thank you for taking the time to present today. With that, I will hand over the webinar to you.
Oh, thank you, Angie. Can you hear me okay?
Yep.
Okay, good. Well, everyone, thank you for attending this presentation, and thank you to the Behavioral Health Association of Providers for giving Zach and I this opportunity to speak to you today. My name is John Mills. I'm here with my law partner, Zachary Rothenberg, and as Angie said, we are both healthcare attorneys at Nelson Hardeman, which is a California-based healthcare law firm. Zach and I both litigate, and we advocate exclusively on behalf of healthcare providers. And a big part of my practice has been helping my clients get reimbursed for their services from commercial payers. It's something I've been doing for almost 20 years now. In fact, I just attended my 20-year law school reunion a few weeks ago. So it's kind of, can't believe how time flies. But in that time, my practice has moved steadily more in the direction of representing behavioral health providers. And I think that's largely due to personal interest, but it's also because, at least from my perspective, it's where most of the action is, at least the interesting action. And that is thanks to the persistent development and, in my perspective, the improvement of the mental health parity laws. As mental health parity legislation has been strengthened over the years to require more insurance coverage for mental health and substance use disorder treatment, there continues to be plenty of disputes and plenty of litigation. Let's face it, insurance companies do not always see eye to eye with providers and plan beneficiaries when it comes to reimbursing for services. And our goal with this presentation is to help you better understand recent developments in the mental health parity laws that are designed to help you get paid for your services, even if the payer you are dealing with doesn't want to pay, which is often the case. We are going to focus primarily on California's Senate Bill 855, which went into effect last year and which provides a model for improving parity legislation at the national level as well as for other states. We'll then touch on some recent developments at the federal level before concluding with key steps that providers can take to leverage the parity legislation to improve reimbursement from commercial payers.
So let me tell you a little bit about myself, and then I want to tell you about our firm as well. So again, I'm Zach Rothenberg, also a partner at Nelson Hardiman. I spent the first 10, 12 years of my practice as really a general commercial litigator with sort of an emphasis in the entertainment world. And after a number of years realized that that world was not really for me. And I fell into doing some work in healthcare and realized that those were my people, and really enjoyed working with folks in the healthcare space and their sort of left brain thinking. And since then, have joined Nelson Hardiman and really focused exclusively over the past 6 or 7 years on healthcare and healthcare disputes in particular, with an emphasis, like John, in behavioral health. To me, it really feels like a calling, and like I'm really making a difference in part of what feels to me like a movement in ensuring parity and rights for behavioral healthcare. So our firm, Nelson Hardiman, again, 20 lawyers. All we do is healthcare. Our our reimbursement practice focuses on payer disputes, both in commercial and public payer, meaning government payer contexts, for a variety of healthcare providers, including and largely focused on behavioral health. I should also mention that my firm handles corporate and transactional and regulatory compliance matters for healthcare providers. And we really think of ourselves as a full service firm for the healthcare industry. And before we begin, let me just say that because we're lawyers, we have to give this brief disclaimer. We should emphasize that today's discussion is really intended to be general and doesn't constitute the giving of legal advice, at least not specific legal advice. There's no attorney-client relationship created by attending this presentation, and we would encourage all of you to seek counsel that has an expertise in healthcare in whatever jurisdiction you currently are residing in or doing business in. And before I forget, we will have time for questions at the end, but let's please keep them until the end. And I believe you can type them directly into the chat box, and Angie will find them and filter them to us. And without any further ado.
Okay. Well, let's start by diving into a discussion of California Senate Bill 855, which is a new parity law in California that truly strives to improve reimbursement for mental health and SUD treatment providers. We'll also discuss some other notable developments in the mental health parity laws. All right, well, what is mental health parity? That may seem like a pretty basic question that most of you feel like you can answer, but I still would like to start by going over some fundamentals. I actually had the opportunity to listen to the author of SB 855, California Senator Scott Wayner, discuss his motivation for this bill. And for him, it boiled down to the recognition that mental health disorders are a disease of the brain. And that recognition is truly the underpinning of all mental health parity laws. Thankfully, our society has moved away from the view that mental health problems and substance use addiction are purely moral failings. We recognize now that we are dealing with health conditions and disease that requires treatment to improve and hopefully overcome. Unfortunately, however, the cost of mental health care in this country is very high, and many, if not most, will forego treatment altogether for their mental health condition without adequate insurance coverage. So, mental health parity simply means health insurance coverage of mental health disorders on terms and conditions that are no less favorable than medical and surgical benefits. So to take some simple examples, if your health insurance plan covers medications, then it needs to cover medications not only for treatment of physical ailments, but also medication to treat mental disorders. If your plan covers physical therapy, it also needs to cover therapy provided by a psychologist. If there is a cap on the number of lab tests that your plan will cover for addiction treatment, but there is no corresponding cap on the number of lab tests for medical and surgical treatment, then that would be an example of non-parity. Trying to get to the slide here. Okay. All right. So Senate Bill 855, it builds on decades of prior mental health parity legislation. It didn't just come out of the blue. And I'm going to give a quick history of mental health parity legislation with this slide. In 1996, Congress passed the Mental Health Parity Act, which was most notable for requiring the use of comparable annual and lifetime dollar limits for mental health care and medical care. Then the problem with that law, though, is that it did not require comparable visit limits. And so what payers did to get around it is they just changed their policies from having dollar limits to visit limits. In 1999, California passed the California Mental Health Parity Act, and it required coverage of medically necessary treatment of 9 listed severe mental illnesses. The law applied to healthcare service plans regulated by the Department of Managed Healthcare, or DMHC, as well as disability health insurers regulated by the Department of Insurance. But some of the problems with the 1999 Act is that it only recognized coverage for those 9 mental illnesses, and it did not include substance use disorders. In 2008, we get the very important federal parity law known as IMPEA. It prohibits covered plans from imposing financial requirements and treatment limitations that are more restrictive for mental health and SUD services when compared to medical and surgical services within certain benefit categories. So benefit categories could be inpatient, in-network services, or out-of-network outpatient services, or in-network outpatient. Those are all benefit categories. Emergency care is another benefit category. The federal parity law applies to plans governed by the federal ERISA law, and therefore has wide-ranging effect, given that many Americans get their health insurance through their employers. In fact, probably most Americans get their insurance through their employers. Then just a few years later, in 2010, as part of the Federal Affordable Care Act, mental health and addiction coverage was made one of the essential health benefits that must be included in any plan that's sold through an ACA marketplace. A significant limitation, though, with these laws was the lack of a definition of medical necessity. The plans and the insurance companies have always been free to develop their own criteria for determining medical necessity. So, not surprisingly, that gap in the laws has resulted in frequent litigation. Perhaps the most significant lawsuit is Witt versus United Behavioral Health. And that was a class action filed in the Northern District of California in 2014 on behalf of United Health policyholders, claiming that United imposed overly restrictive medical necessity criteria for mental health and substance use disorders. In March of 2019, the court ruled that United created flawed level of care placement criteria that were inconsistent with generally accepted standards of mental health and SUD care. According to the court, United did this to mitigate against the cost of complying with IMPEA's requirements. So very significantly, the Witt case is specifically discussed in the legislative findings for Senate Bill 855. And the trial court's findings were adopted in certain respects by the California legislature. Unfortunately, last month, the Ninth Circuit Court of Appeals reversed the trial court's ruling in Witt and essentially held that United was not required to develop criteria that was consistent with generally accepted standards of care. So we'll talk more about the Witt case and its potential impact on SB 855 a little later in the presentation. Okay. This slide lists the provisions of the Health and Safety Code and Insurance Code, which have been revised and added as a result of Senate Bill 855. The law applies to healthcare service plans regulated by the California Department of Managed Healthcare and health insurance policies regulated by the Department of Insurance. Employer-sponsored health plans that are self-funded, government plans, and health insurance that is issued out of state and regulated in another jurisdiction are not within the scope of SB 855. The most immediate impact of the law is that it expands coverage to all mental health and substance use disorder conditions. The law specifically defines mental health and substance use disorders to mean, quote, a mental health condition or substance use disorder that falls under any of the diagnostic categories listed in the Mental and Behavioral Disorders chapter of the most recent edition of the World Health Organization's International Statistical Classification of Diseases and Related Health Problems, or that is listed in the most recent version of the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders. So the legislation clarifies that treatment of these covered conditions must be covered in the full spectrum of level of care setting when medically necessary. And that includes residential treatment, partial hospitalization, IOP, therapy sessions, and medication for managing these covered conditions. Health plans and insurance companies are not permitted to limit benefits or coverage to short-term or acute treatment. And this is significant because one of the main complaints from both patients and providers is that insurance companies often will not authorize more than a couple of weeks of inpatient residential care, thereby forcing a premature step down to an outpatient level of care when the patient is not ready. SB 855 also requires parity as to patient financial responsibilities for covered conditions, such as maximum annual and lifetime benefits, co-payments, co-insurance, deductibles, etc. So, for example, it would violate the parity requirement of SB 855 if a policy had different out-of-pocket maximums for mental health treatment and surgical treatment. Or to take another example, if the co-insurance for inpatient treatment for a medical condition was less than for inpatient treatment for SUD. So there's many examples that we could come up with, but those are just some basic ones. And if I didn't already mention it, SB 855 went into effect on January 1st of 2021, and it applies to applicable plans and policies that are issued, amended, or renewed after that date.
Okay, so let's talk about the medical necessity criteria. As mentioned, a major loophole in both the prior California Parity Act as well as the existing federal Parity Act is that insurers and their administrators had really wide latitude to deny or to limit coverage for treatment by developing their own definitions of what medical necessity is. SB 855 attempts to close the loophole by requiring uniformity in the determination of medical necessity for mental health and substance abuse disorder services. The law expressly defines medically necessary treatment of a mental health or substance use disorder as, quote, service or product addressing the specific needs of the patient for the purpose of preventing, diagnosing, or treating a condition, including minimizing the progression of the condition, provided that three criteria are met. And the first of those criteria is that the service must be in accordance with the generally accepted standards of care for mental health and substance use disorders. Second, the service must be clinically appropriate in terms of the type, frequency, extent, site, and duration. And third, the service must not be primarily for the economic benefit of the plan or the subscribers or for the convenience of the patient or the treating physician or other healthcare provider. So essentially, it can't be financially motivated. SB 855 goes even further and defines generally accepted standards of mental health and substance use disorder care by reference to care and practice, quote, generally recognized by healthcare providers practicing in the relevant clinical specialty. And furthermore, the statute specifically requires insurers to rely on criteria and guidelines set forth in the most recent versions of treatment criteria developed by the nonprofit professional association for the relevant clinical specialty. And this is a really big deal. We represent mental health and SUD providers all the time in disputes that are based on whether or not there was medical necessity. And it feels like we've always had one hand tied behind our backs because we're really at the mercy of the insurance company's own individualized definition of medical necessity. And this is really the only black and white law that we've seen whereby medical necessity is resolved based on the provider's perspective and not the payer's perspective. And before we go on to the next slide, I want to go back to the Witt case that John mentioned. That's the federal class action that was brought against United in the Northern District of California. The trial court in the Witt case expressly found that United erred in how it processed claims because its medical necessity guidelines were inconsistent with generally accepted standards of mental health care. The Ninth Circuit, though, in this recent reversal, they decided no. They decided to reverse because, in the appellate court's view, United was free to interpret its insurance policies as not requiring consistency with generally accepted standards of care. So they completely reversed on this concept. Now, the Ninth Circuit's ruling ultimately has more to do with federal ERISA law than anything related to mental health parity. We're not going to get into ERISA here, but I wanted you to be aware that the Ninth Circuit recent reversal in Witt might cause some insurance companies or administrators to argue that the California legislature's findings for SB 855 are flawed because they were based on the Witt decision that has since been reversed. I don't agree with that. And I would argue that the legislature made its own independent policy decision, based on the lower court's decision in Witt, but it is not dependent on the court's decision there. And we believe that policy decision was intended to improve and strengthen mental health services in California. And that's really completely independent of the Witt case.
We should also mention that the lawyers who are representing the class in the Witt case, they have filed a petition for rehearing at the Ninth Circuit. So that case by no means is over. There's still plenty of litigation ahead of us. Who knows, that case may end up in front of the U.S. Supreme Court. We'll see.
Absolutely. So standard of review. Another major development from SB 855 is that it prohibits and renders, quote, void and unenforceable language in health plan contracts that confer discretion on the plan or the plan's administrators to make benefits and coverage determinations that lead to a deferential standard of review by a reviewing court. Now, this is important because courts have generally given deference to the decisions of plan administrators when reviewing coverage determinations, including based on medical necessity. In fact, that's exactly what happened in the recent Ninth Circuit decision in Witt. The court simply reasoned that the trial court had failed to afford the proper amount of deference to United's interpretation of the policy provisions. So SB 855 appears to mandate that courts apply what's called a de novo standard of review when they are interpreting a plan provision to determine whether a coverage decision was correctly made. And de novo means that the court can interpret the policy or the insurance contract as if it's looking at it for the very first time without regard to what anybody else thought about it. It's their own fresh take. And this should make it easier for plan enrollees to proceed to court and providers to proceed to court with claims that plan administrators are in breach of the plan. So again, big news. Out-of-network coverage. SB 855 also provides that where medically necessary services for mental health and substance use disorders are not available within the plan's existing network, then the plan or insurer must arrange to provide services to secure medically necessary out-of-network options that are available to the enrollee within geographic and timely access standards. And at the same time, plans must also ensure that the enrollee's cost-sharing obligations, like deductibles, are no higher for the out-of-network services than what the enrollee would have paid for the same covered services from an in-network provider. Coverage for out-of-network providers at in-network cost-sharing amounts must also be provided if an enrollee is unable to find timely treatment at a reasonable distance from home. And it's not entirely clear from the text of the statute what a reasonable distance is. Other similar statutes have generally considered this to be 15 miles or 30 minutes. Simply put, if the member can't access an in-network mental health or SUD provider in his or her network or geographic area, then it will be incumbent upon the insurer or the plan administrator to find an out-of-network provider in that geographic area without it costing the member more out of pocket. And notably, this does not mean that the out-of-network provider must accept an in-network rate in this instance. It just means that the patient is responsible only for their in-network share. And to the extent there is a gap to cover, it's up to the plan or the insurer to cover the difference. Next slide. So reimbursing pre-authorized services. SB 855 also clarifies that health plans and health insurers are prohibited from refusing to pay for medically necessary services that have been pre-authorized through utilization review. And this is true even if the insurer has determined that the treatment was authorized in error, for example, including because it turns out the patient wasn't eligible for benefits or the policy had lapsed due to non-payment of premiums or something like that. The idea here is that the insurer is in the better position as opposed to the provider to make the correct decision about coverage and eligibility, and therefore it's really the insurer that should bear the cost of its mistake and not the provider. This section, by the way, only applies where the healthcare services were rendered in good faith and pursuant to the authorization. So, for example, false and fraudulent claims won't be protected by this statute, nor would claims for services that were procured illegally, for example, through kickback arrangements, and nor would it cover claims that were authorized based on knowingly false information provided by the provider in order to get the authorization in the first place.
All right.
Sorry. Maybe both clicked. There you go.
All right. Okay, so there, SB 55 is the statute's there. It's it will probably be some court fights in the future around it. But first and foremost, we're expecting that both the Department of Managed Healthcare and the Department of Insurance will be promulgating regulations to further clarify SB 55's requirements. And that will hopefully provide some additional tools for enforcing compliance with the statute. In fact, the statute specifically authorizes the departments to conduct administrative hearings regarding alleged violations of the law and to assess penalties against violators, against insurance companies and administrators that violate the law. But not surprisingly, health insurers and health plan associations, they strongly opposed SB 55. So having lost the fight to prevent passage of the law, it will be interesting to see if the insurance industry tries to take some of the teeth, the enforcement teeth out of SB 55 through the rulemaking process. So again, that process is underway, and we're kind of all anxiously waiting to see the final regs on that. Unfortunately, from my perspective at least, SB 55 does not contain a private right of action. That means the statute itself does not state that a private individual or private company can sue directly under the statute if it's being violated. Nonetheless, there are several avenues for patients and providers to try to bring civil actions for wrongful denials of mental health coverage. First of all, there is California's unfair competition law, which may be useful to obtain injunctive and declaratory relief. And you could also try to file a claim for breach of contract or breach of the implied covenant of good faith and fair dealing, because SB 855 specifically states that plans and insurers shall not enforce terms in writing or in operation that undermine, alter, or conflict with its requirements concerning medical necessity determinations. So even if you couldn't point to a specific policy provision in the insurance policy that was being breached, the requirements of SB 855 would be implied in the plan, and therefore any terms or operational practices that were inconsistent with SB 855 would arguably be a breach of the plan itself. And that could be enforceable by the provider if they have obtained an assignment of the plan benefits. And of course, it can be enforced by the policyholder. And I'm also curious to see how things develop around the provisions of SB 855 that require plans and insurers to arrange for out-of-network services at the same cost-sharing amounts as in-network services, because the statute does not clarify who gets to determine whether medically necessary treatment is available in-network in the patient's geographic area. So I wouldn't be surprised to see disputes about whether this provision is violated when out-of-network providers are not fully reimbursed. If I'm representing an out-of-network provider, I'm going to want to argue that the services they rendered were not available to the patient within the plan's network, and they should be reimbursed at the fair market value rate of the services, also known as a UCR rate. But plans and insurance companies are going to try to argue that no, the out-of-network provider is only entitled to be reimbursed at an in-network rate under those circumstances. The language of the statute, as Zach mentioned, it's very protective of patients in making sure they are not out of pocket any more than they would have been had there been an available in-network provider. But the statute is silent on the rights of out-of-network providers to be paid their bill charges. So this is an issue that hopefully will be clarified in the final regulations that are issued by the enforcement agencies. I also want to, just before we move on, I want to say that I do expect to see litigation around whether plans and insurance companies are adopting clinical criteria and guidelines that are consistent with SB 855's requirements. I mean, that's probably the most important aspect of the law. But insurance companies are they're gonna try to find loopholes in that. In fact, I was at a conference just a few weeks ago talking about these issues, and we were specifically talking about how for autism there are not currently any existing published criteria by a nonprofit organization. There's sort of a mishmash of stuff out there, and an insurance company representative said, well, as a result of that, we're taking the position that SB 855 doesn't apply to autism, which is crazy because the law specifically includes autism in its definitions of healthcare providers, of mental health care. So it's clearly the law is intended to include autism. But the insurance companies are going to try to say, well, we get to fall back on whatever standards we want to come up with because there's not any generally accepted standards of care in the industry for autism because there's not any published nonprofit criteria. So those are the kinds of things that we're going to see in battles ahead, and so insurance companies are not just going to roll over on this stuff. They're crafty, and they will certainly look for some loopholes if they can. Now let's switch gears a little bit and talk briefly about the federal IMPIA law. Because while California now has the strongest parity law in the country, SB 855 is limited in scope and applicability, whereas the federal IMPIA is still the main law that most people in this country are going to rely on to enforce rights to have coverage for mental health and SUD treatment. IMPIA prohibits covered plans from imposing financial requirements and treatment limitations that are more restrictive for mental health and SUD services when compared to medical and surgical services within certain benefit categories. And as I mentioned before, a benefit category could be something like emergency care or inpatient in-network care, something like that. MPIA has very broad application. It applies to most commercial insurance plans, including group plans regulated under state law, and it applies to self-funded health plans regulated under the federal ERISA law. MPIA functions by targeting plan limitations that violate parity, and there are two types of limitations. First, there are quantitative treatment limitations, otherwise known as QTLs, and these deal with numerical benchmarks. For example, if the plan has a lower number of covered visits for inpatient mental health facilities than it does for inpatient medical stays, that would be an unlawful QTL. QTL violations are fairly easy to spot because you're really just looking for numerical differences between mental health and medical care. Non-quantitative treatment limitations, or NQTLs, those are much more difficult to identify, and that's where not surprisingly, all the action is. Those deal with insurance company processes, methodologies, utilization review, medical necessity criteria, more of those sort of subjective issues. And just to give an example, if a plan requires that a beneficiary undergo outpatient therapy before being admitted to an inpatient program, that would be an unlawful NQTL if the plan does not also require a visit to an outpatient medical provider prior to being admitted to an inpatient medical facility. So with NQTLs, you're always doing that comparison between what they require or what they limit on the mental health side with the medical side. But it's a more difficult analysis when you're not talking about numerical limitations. The MPIA law has proven, though, over the years to be a very, very useful law to challenge insurance treatment denials. And just to give one recent example in California, the law was used to file suit against United in federal court, and the court held that MPIA was violated because United excluded intensive behavioral therapies such as ABA for autism spectrum disorder. In that case, the particular plan covered autism, so the court reasoned that it would be a NQTL violation to exclude a specific treatment that only applied to autism. United was not able to show a comparative treatment exclusion for medical and surgical conditions. In other words, it wasn't like, I think the court even maybe commented, United's not able to show that it excludes chemotherapy for cancer treatment. So why are they covering autism but excluding particular therapies? Another significant development in the world of MPIA is Section 203 of the 2021 Consolidated Appropriations Act. And this requires health plans to create comparative analyses of their NQTLs and disclose those reports to their members upon request. So plans carry the burden to prove that their NQTLs do not violate MPIA. And Section 203 is designed to make sure that plans are meeting that burden. And we'll talk a little bit later in a few minutes about the importance of sending requests to plans to force them to disclose their NQTL analyses. We'll continue with a few more recent MPIA developments. So MPIA requires that the Secretary of Labor submit periodic reports to Congress regarding plan compliance with MPIA. The 2022 report that was recently submitted builds on Section 203 of the Consolidated Appropriation Act because the Department of Labor developed its report after one of its sub-agencies, known as the Employee Benefits Security Administration, or EBSA. It used Section 203 to require numerous plans to submit their comparative analyses of plan NQTLs. They had to submit them to EBSA for review. And some of the key findings in the report after EBSA made these requests were that every single NQTL comparative analysis that was reviewed by EBSA was found to be initially insufficient. And there's a variety of reasons why they were found to be insufficient. I'm not going to get into them, but it was just interesting that not a single health plan was able to supply a comparative analysis that complied with Section 203. Granted, Section 203, is a new law, but it was interesting. And then of the compliance reviews conducted by EPSA of 48 NQTLs submitted by 30 different plans, there were multiple non-compliant NQTLs relating to the exclusion or limitation on residential care or PHP to treat mental health and SUD conditions. And there were even more exclusions on medication-assisted treatment for opioid use disorder. That was one of the highest exclusions, as a matter of fact. As a result of these reviews by EPSA, many of these NQTL restrictions were voluntarily removed by the plan. So that was a useful or a great result from the Department of Labor's initiative there. But what's also very interesting about the report is that there were several conclusions about what should happen going forward. And one of the main conclusions is that the Department of Labor is calling for more enforcement power under IMPEA. They specifically are saying Congress should give Department of Labor the authority to assess civil monetary penalties for parity violations against both plans and their administrators. So this would in effect give the Department of Labor the power to enforce IMPEA in the same way that the California legislature has given power to enforce and assess penalties to DMHC and Department of Insurance when they're enforcing SB 855. And thankfully, the Department of Labor also recognized in the report that IMPEA currently gives too much latitude to payers to determine what constitutes a medically necessary mental health benefit, and therefore IMPEA should be amended to define mental health and SUD benefits in an objective manner based on nationally recognized standards. So this report came out before the Witt ruling, the Ninth Circuit's Witt ruling. And while the report does not mention the Witt case, it does not mention SB 855, it seems that the Department of Labor is essentially calling for IMPEA to be amended in a manner that would follow the trail that's already been blazed by SB 855. And then, of course, not long after this report, the Ninth Circuit issued its ruling in the Witt case. So for those on the side of advocating for greater parity protection and enforcement, like myself, like Zach, we consider the Ninth Circuit's ruling to be terrible. It's very short, it's cursory, and it's not a very thoughtful court opinion. But the ruling is because it's essentially grounded in the fact that IMPEA does not contain objective standards for determining medical necessity. We're hopeful that between the Department of Labor's IMPEA report and this terrible ruling, which is going to be aggressively challenged by the plaintiffs in that case, we're hopeful it will catch the attention of Congress and they will, in fact, amend IMPEA to closely resemble SB 855. We certainly hope so.
All right. So hopefully we've now provided you with a decent understanding of the parity laws. I know we got into the weeds a little bit, but hopefully not too terribly deeply. Now let's change up our plan a little bit and let's briefly discuss how you can leverage that understanding of the parity laws to your benefit in payment disputes. So first, let's talk about things you can do before the dispute arises. First, make sure that the services for which you seek reimbursement are rendered by a provider with the appropriate qualifications, certifications, credentials, etc. You'd be surprised how often we have clients who are not getting paid or are subject of clawbacks or audits from insurance companies because their services are not being rendered by the right providers. And recall that SB 855 only provides protections to quote unquote healthcare providers, which is defined to require that the provider possess the necessary qualifications and credentials. In other words, you can't invoke the protections of SB 855 if your services are not being rendered by a qualified professional. Second, make sure that you are adhering to generally accepted standards of care based on criteria and guidelines set forth in the most recent versions of treatment criteria developed by relevant nonprofit professional associations. As we discussed earlier in the hour, the most significant change brought by SB 855 is that it effectively prohibits payers from making up their own individualized medical necessity criteria to suit their purposes if it's inconsistent with generally accepted standards of care. So if you're going to dispute and challenge a payer's criteria as being overly restrictive or arbitrary, you need to make sure that you can show that your services are consistent with those widely accepted treatment criteria, rather than trying to defend criteria that you came up with on your own or that don't have evidentiary support. Third, maintain good clinical documentation. That one sounds easy and obvious, but believe me, poor clinical documentation is the number one most common reason that we encounter for overpayment disputes, by which I mean the payer wants a refund of money that it's already paid. You can have the best, most high quality services in the world, and your patients can all love you. But if you do not meticulously document your services and get timely signatures from your providers, etc., then it's as if the services were never provided. There's an old adage in healthcare, if it isn't documented, it didn't happen. Oh, I'm sorry. Hang on. I missed a couple. Fourth, and similarly, maintain good intake documents. The types of documents I'm referring to here are the assignment of benefits, which is the assignment from the plan beneficiary to the provider of the benefits that the beneficiary has under the plan or the insurance contract. This enables the provider to get paid directly from the plan, and in the case of an ERISA plan, gives the provider standing to sue. Number two, the designation of authorized representative. And this is similar to the assignment of benefits, except that this is a document the beneficiary signs to designate the provider as its representative for purposes of appeals to the insurer. Often plan administrators will insist on the signed designation of authorized representative before they'll respond to a document request or appeal submitted by a provider. The verification of benefits. As you hopefully know, verifying benefits is the process of contacting the insurer or the plan administrator to verify that the patient has active benefits for the services you intend to provide. You want to make sure that you are documenting that verification in real time, because you may need it down the road if the insurer tries to deny coverage on the ground that there was no active coverage at the time of services, or to pay the claim in a manner that's inconsistent with what they reported to you during the VOB process. The VOB can also be extremely helpful in litigation should the need arise to establish that the insurer or the plan administrator directly owes the provider a duty to pay for services. And the best practice, in my view, is to develop a sort of fill-in-the-blank style script that your staff can use to ensure that they are obtaining all of the information that you may need down the road. And authorizations. Like verification of benefits, you want to carefully document any prior authorizations that you receive from the payer, because this can also help establish that the insurer directly owes the provider a duty to pay for the services. And recall that SB 855 specifically prohibits a payer from refusing to pay for pre-authorized services. So you want to make sure that you have this evidence of the authorization.
Okay. In the interest of time, I'm just going to go through this really quickly. Again, we want you to be attuned to potential parity violations when you're dealing with insurance companies, both at the outset when you're first intaking a patient or admitting the patient, and then of course during the claims process, during the appeal process. Not every single limitation is a parity violation. We're not trying to convince you of that, but you should always have, if you see a restriction or learn of a limitation that raises your eyebrows, it's probably worth investigating. And this slide here is just showing a handful of limitations that should grab your attention if you were to see something like this. Obviously, we talked about before, very easy ones: financial and quantitative limits. If there were, for example, an annual limit on the number of outpatient visits, you would want to double check and say, well, is there an annual limit on the number of outpatient visits for medical care? There probably isn't. So, but if there wasn't, that would be a clear parity violation. And I understand the difficulty of being able to find out what the plan's requirements are. And often you're going to need to try to get a hold of the plan, but you can also use that Section 203 under the appeal law when it comes to employer-sponsored plans or any law that's subject to APIA's requirements to request right from the outset, before you get into a dispute, just right from the outset, get the patient to sign that DAR that Zach talked about and send in a request asking for a disclosure of the treatment limitations. Now, you may not get it. I mean, it's in fact more likely than not that request will be ignored. But keep a record of it, because if they are ignoring those requests, then they're violating that requirement as well. So some of the NQTL violations on this slide, let me just quickly discuss. If you come across what seem like overly stringent clinical criteria or medical necessity determinations that seem just wrong in your view, again, that's where you should be doing a comparison with the generally accepted standards of care. If you're an SUD provider, you should be comparing the payer's criteria with ASAM, for example, and that could be a basis to challenge it. If there are fail first protocols, which mean a patient is required to undergo some lower level care prior to being eligible to undertake a higher level of care, and fail those lower levels of care, those are typically considered to be parity violations. So if a plan is imposing those types of limitations, that's definitely something you should challenge. And conversely, if they're limiting coverage to short-term or acute treatment, so if they're saying, well, we're only going to provide coverage when the person is experiencing some sort of acuity, some sort of acute symptom, and they're only going to cover for 2 weeks, that's probably going to be a parity violation. There are other types of violations that are known as scope of service limitations. One that Zach and I ran into last year with United. United had published this memo where they were saying they were going to no longer allow their insureds to obtain treatment out of state for out of network services. Now, on its face, the document said it will apply to both medical as well as mental health. But in practice, we felt that it would have a disproportionate effect on mental health care. And we think that was the reason why United was putting that out there. Now, it's a little strange because it seems like maybe United, got a lot of blowback early on, because we haven't heard much since then about it being enforced. And it's not clear that it's being enforced at all. But that would be a potential parity violation if it was being enforced. And then, of course, we see a lot of fights out there regarding repricing policies for out-of-network services. Those could be parity violations depending on whether the plan is targeting mental health and SUD providers in their repricing policies. Now, again, repricing in and of itself is not a parity violation, but depending on how it's being implemented, that could put it into a NQTL violation.
All right, I think we have 2 slides left and only a couple of minutes, so I will move quickly here. When in doubt, send the appeal out. It is critical when a claim is denied or is paid in a manner that you think is problematic, you send out an appeal, always. For starters, if you don't timely appeal and then later you want to file a lawsuit, there's a good chance that your lawsuit will be dismissed right off the bat because you have failed to, quote, exhaust administrative remedies. And that's a judicial doctrine that says you basically can't have standing to file a lawsuit until you've gone through all the plan's internal appeal mechanisms and hoops and pitfalls. Of course, make sure that your appeal is timely because all plans have very clear black and white appeal deadlines that you must follow. And don't just send a letter saying you dispute the plan's decision. Back it up with supporting documents. And finally, be careful not to get bogged down in endless phone calls with plan representatives and repeated written appeals. Don't get lulled to sleep with the appeal process. Keep in mind that there is a statute of limitations running. And at the end of that statute of limitations, some period of years, if you haven't actually filed a lawsuit, you may be forever barred from doing so if that's what you wanted to do. And in terms of tips for effective appeals, number one, allege a parity violation. Even if you're not certain that one exists, plans carry the burden to show parity compliance, both as written and in operation. Meaning, if you can if you have enough information to just raise the issue, it will be up to the plan to disprove it, and not necessarily your job to prove it. Number two, using a signed designation of authorized representative, request the plan's NQTL comparative analysis that John has been talking about. This information will help you evaluate potential parity violations, and it will also send a really clear message that you know what you're doing. Along the same lines, using the DAR, the designation of authorized representative, request plan documents, medical necessity determinations, pricing methodologies, etc. And again, there's valuable information in those documents, but it also sends a message that you're the squeaky wheel, that you know your rights, and you're not the one to be messed with. The appeal should be comprehensive, supported by evidence, and be organized in what you're doing. Date your correspondence, confirm receipt, keep copies, keep an updated spreadsheet or log so that you can track responses from the insurance company, or payments from the insurance company, or any progress or lack of progress that you're making on each and every one of these appeals. And with that, and if there's any questions, we've got some time.
It looks like we do have one question in the chat.
Actually, we have a couple. Tara asks, does SB 855 apply to Medi-Cal?
No. SB Medi-Cal has its own, subject to its own parity violation.
And then Leslie says, I find VOB or SUD treatment can be determined by provider in as little as 90 minutes, but VOB on BH can take days, weeks. What could be the reason for this inequality? As providers, what can we do about it?
I'm going to go out on a ledge and say BH is behavioral. I'm
behavioral health, I'm assuming.
I thought so.
Days or weeks.
Huh. That's interesting because it's not really. Yeah, I haven't heard that either, and it's not necessarily a parity issue because they are authorizing they are verifying the SUD treatment fairly quickly.
The other thing I can think of is that I wonder if the payers are attuned to SUD in particular because there's been so many legal battles, and that they're really focused in on sort of closing that loophole and making sure they're covering their bases on SUD and not as rigorously controlling their sort of internal procedures for the rest of BH. I don't know. That's pure speculation.
Yeah, I haven't heard that before, so I would want to. I guess I'd want to know more details, more facts.
I can pull Leslie onto the stage if they don't have an objection to that.
While you're doing so, I do want to clarify regarding the Medi-Cal. I should say that Medi-Cal managed care policies, if the policy is regulated by Department of Managed Healthcare, then it would be subject to SB 855. But if it's straight fee-for-service Medi-Cal, it's outside of SB 855.
If you can't get Leslie up on the screen, if she would give one of us a call, we'd love to hear more.
Yeah, I'm here.
Oh, hi.
Can you hear me?
Yes.
Okay.
Yep, I can.
So I have worked in both addiction medicine and behavioral health. I'm a PhD. And when I have called for verification of benefits on SUD, I can get an answer right away on clients. But with the same healthcare provider, when I have called to get like an adolescent into IOP, PHP treatment or residential or a young adult, it can take days or weeks for them to make a determination. And I'm just wondering, you know, it all goes back. And I have spoken in front of the Santa Monica City Council eons ago about this, that, you know, the brain is part of the body and it should be treated just like if somebody has cancer or breaks a leg. You know, it should be treated no differently. And in the long run, insurers will save more money if they nip something in the bud, because when I have dealt with addicts who are in and out in a revolving door situation through rehab and detox, 60 years old, still living in their childhood bedroom with their mother with the posters on the wall, and failure to launch, never held a job, versus a 14, 15-year-old kid that we can get early and put through a program so we can prevent those years of suffering and hundreds of thousands of dollars in rehabilitative services with SUD. It would make more sense to me, but then I'm a pragmatic person, to take care of behavioral health issues earlier, because most substance abuse addiction is a dual diagnosis situation. I'm sorry, I have to take this call. I have to
Okay.
Okay. Well, I'll just give my thoughts on it. Because it's a verification of benefits, I'm just shocked that it would take that long to get a VOB. I mean, authorization would be maybe something that I could expect taking longer because maybe the issues are more complex. But a verification of benefits should be easy. The payer, the representative, should just be able to look it up to see what the benefits are. So I'm wondering if the issue has something to do with the provider, and there's some questions or confusion on the payer's side regarding the provider's kind of status or licensure status or something to provide both levels of care. That's I'm speculating, but everything Leslie said I agree with. I just don't necessarily know why the VOB process would take longer. I've never heard something like that. Zach, any ideas in your end?
No, I mean, if the issue had been why are VOBs taking longer for behavioral health versus physical health, I think we could talk about that all day. The curveball here is that it's behavioral versus SUD that makes it confusing to me.
Yeah, absolutely.
Okay, well, Leslie, you have their contact info if you want to follow up with that. I want to thank John Mills and Zachary Rothenberg for presenting today. Thanks as well to you for participating. We hope you join us for future BHAP webinars. You can sign up for our various newsletters, which includes emails specific to upcoming events, at our website, www.bhap.us. With that concludes today's webinar. Thank you very much.
Thank you.
Thank you.